Trute versus Trute, case number 2308472DM. Present in the virtual courtroom, we have both parties as well as their respective attorneys. And we are here on a motion filed by the plaintiff to modify support. And Mr. Stoner.
Yes, Your Honor. If I may proceed.
Yes, you may. And I've read everything.
Okay, wonderful. I'll try not to recapitulate everything, but there are some extraneous issues that were kind of brought in on the response that I think is important to address, given the request that my client be held in contempt. As the court is aware, there are pending felony charges for 2 counts of child abuse, 3rd degree, against the defendant mother. And as part of that criminal case, there was a no contact order with respect to the minor children. Additionally, the parties effectively mirrored that by suspending mother's parenting time on April 24th. Yes.
I know all of that. So
okay, very good, very good. So my client, it's pretty straightforward. Mother doesn't have parenting time. Father has sole parenting time, and he's requesting that the court suspend his child support obligation. And how he put it in his pro se motion was that they reverse the child support, effectively asking that child support be assessed against mother on a temporary basis during this abeyance period of mother's time with the children. With regard, I could give some case law citing the court's authority to do this. There's Romaine versus Romaine. Okay.
I'm very aware of I've been doing this for 35 years, so you don't need to cite it for me.
Okay, very good.
Okay.
Very good. With regard to
a virtual court hearing began as attorneys addressed a motion seeking child support modification following criminal allegations that dramatically altered custody arrangements.
To the response filed by the defendant, I would state that, well, first he asks that, he states that because the temporary order the parties entered did not reference child support, that therefore child support should by de facto not be included. I don't think that that is reasonable. To make that to apply that would say that every order has to be all encompassing and that it must address everything, or else if it doesn't, then it's off the table. I don't think that that's consistent with the law. The law does provide that the court is allowed to apply support retroactively under MCL 552.603 to the time of the petition, which is what we're requesting today, both that his be suspended and that support be assessed. With regard to the arguments related to the school, I don't know if the court wants to hear them, but
I did see that they were that one was noticed up for July.
Correct.
Their objection was.
Yes.
Okay. So I guess I would say that's not before me today.
Okay. And just with regard to the request in the response that my client be held in contempt and jailed, I would say rule MCR 3.606 governs contempt proceedings, and it provides that an ex parte motion must be filed and an order entered, proper service must take place, and then the court can issue an order to show cause. None of that has taken place. Therefore, procedurally, I'd say as a matter of due process, I think it would be improper for my client to be held in contempt
That
today.
is not before me today because it has
Very
not
good.
been properly brought before the court.
All right, thank you. Nothing
All right.
further at this time.
Mason.
Yes, Your Honor. First of all, we believe that Ms. True is innocent of these charges, and we can prove it. But that's not in front of us today. He's asked.
The father's attorney argued that sole parenting responsibilities justified suspending support obligations while requesting temporary financial assistance be assessed against the mother.
The suspension of child support, we had a stipulated order that didn't discuss that. I do want to bring to the court's attention that he is in violation of several signed orders to return the kids. He has not done that to the school for 2 months now. And now he wants to come in here and not only suspend his child support, but now assess it against her. He's overplaying this hand in this trumped up criminal case that she has, which we believe we can win, which is in front of us. So we'd ask their motion be denied in its entirety, and we will be pursuing contempt charges because we had a stipulated order to not move the kids that and bring it back that he completely blew off. We filed an ex parte that was signed. He blew off.
Again, it's not in front of me today, so I can't address it. What is in front of me is a motion to modify support. The law is abundantly clear that child support is modifiable at any time based on a change in circumstances. There's certainly been a change in circumstances here. So I will grant the motion to suspend support, but I will refer it to the front of the court regarding support for an updated recommendation regarding the change in circumstances. And is there anything further?
No, we'll be show causing on that contempt thing promptly.
Okay.
With regard to the date that support would be authorized, would that be to the date of the petition?
Yes, the date of the filing.
Thank you.
Okay. Present in the virtual courtroom are both parties, as well as Mr. Glovett, who has a limited appearance filed on behalf of the former Ms. Jones. We are here on the defendant's motion in order to show cause against Mr. Jones. Mr. Glovett.
Yes, well, this is actually a matter of second impression. This court already heard all of these allegations and entered an order.
After reviewing the circumstances, the judge concluded substantial changes had occurred and approved a temporary suspension pending further evaluation.
October 31, 2026, and this court actually provided one of the more thorough opinions and orders I've seen, and it was very clear what was expected, what the penalties would be. And since that time, that the plaintiff has continued to fail to abide by those by that order. And I received a sort of response from plaintiff, and it seems like there's no real excuse for or denial that these violations have happened. It's more of trying to relitigate this court's October decision. But this court was very clear. This court said you need to make these payments, you need to transfer title, and you need to do it within a certain amount of time. I provided a brief in support that quoted portions of this court's order, and when I do all caps and in bold, that is not emphasis added. That's this court's directives. And this court promised certain relief if this was not handled, and including daily fines. And we're now 189 days from the deadline for the plaintiff to perform these actions. We submitted with our brief in support pictures of post-dated checks in violation of this order. I don't think there's any dispute. This is a really simple situation. This court set forth clear directives and the plaintiff is not following them. Our requested relief right now is a total of $8,454.82 to my client. That includes the $6,899.06 principal owed for her equity in the retirement account, plus $635.76. That's for statutory interest. I provided in the brief of support the calculations following the statutory interest rates for each 6-month section. And then I would ask this court to also pay $920.
A separate hearing followed, involving allegations that a former spouse repeatedly ignored court-ordered financial obligations despite detailed directives and deadlines.
Reasonable attorney fees, that'd be $20 for a motion fee, and $900, which it would just be, 3 hours at $300 an hour. And I would also ask this court to consider imposing a fine. This court is empowered to impose a fine up to $7,500, and perhaps even in a manner in which this court could allow him to purge his contempt if he pays my client what's owed to her within a certain amount of time. Otherwise, he's subjected to that $7,500 fine. I don't know what else we can do. This court's objective with these contempt hearings is just to inspire a party to follow this court's directives, and I'm not sure what else we can do at this juncture after this court has already been so clear. So I'm asking for harsher fines for that reason.
Great, thank you. Mr. Jones, I did read your response. I also noted that you filed a motion for contempt. However, you did not follow the court rules and it is not properly before the court. So I'm just going to ask you And it looks like you literally made a copy of the entire legal file and filed it. So I'm just going to ask you to narrow your response to why you haven't complied with this court's order.
Okay, Your Honor. It says, good morning, Your Honor. For the record, my name is Jeremy Jones. I'm here today to represent myself, and I am respectfully ask the court to dismiss the defendant's motion of show cause and grant my counter motion of contempt.
All right, I've already addressed your counter motion. It's not properly before me, so that's denied.
Okay, so Your Honor.
It's dismissed because it's not properly before the court.
Okay. So the standard for civil contempt requires a finding that I willfully and intentionally defied the court's order. I stand before you today and say that I did not. My inability to pay.
The moving party requested repayment, statutory interest, attorney fees, and stronger penalties, arguing previous warnings had failed to secure compliance.
A lump sum equalization was not an act of defiance. It was a mathematical impossibility. Directly engineered by a campaign of financial fraud and sabotage orchestrated by my ex-wife, Candace Pyre.
All right, let me just stop you there. You cannot relitigate the judgment. This is a very clear, you owe the money. So we're not going to go back and relitigate why you owe the money. You owe the money. And again, the question is, why haven't you paid it? That's the only question.
Your Honor.
Sorry?
I said I don't have it, Your Honor.
Right.
I attempted to try to give Candace the title for the Jeep. She had traffic fines that almost issued me a bench warrant, which would have imposed my ability to be able to get a security clearance that she refused to pay twice. So previously she had tolls that were unpaid.
Again, this has nothing from the perspective of the court right now. There's an order for you to pay this money and you haven't paid it. What she may or may not have done is not relevant to this particular issue.
Okay.
All right. I am going to fine the plaintiff in contempt of court for failing to abide by this court's very clear order. And I will grant the motion in full. I will hold the fine in abeyance, provided that the plaintiff pays the balance due within 30 days. If not, the court will impose the fine and the defendant may reduce the entire amount to a money judgment.
Okay, Your Honor, I don't have any money.
All right.
Your Honor, would you like me to prepare an order, and then if so, would you like me to just put it in the form of a scale form email to your assistant today, or I can submit something under the 7-day rule?
No, you can provide a proposed order via email. That's fine, as long as
I'll have that submitted within an hour.
Representing himself, the accused claimed financial hardship prevented payment, but the judge emphasized the debt's validity and rejected attempts to revisit prior rulings.
All right. The other thing is the attorney fees. I did not see that you attached the required, at least I don't think you did.
Your Honor, you're correct. And so I understand those are denied then. That's fine. That's a minority share of this.
Okay.
We'll withdraw that request.
All right. Let me just make sure I got everything else here. All right. Thank you. We're adjourned.
Your Honor, what about the $1,000 that I already paid her? Will that be taken off of the money owed?
Mr. Glovick, does your accounting show that payment?
Well, we have a number of post-dated personal checks. This court ordered that payments be made by way of immediately available funds, and since they're post-dated, we couldn't cash them out anyway. And when we do, they may or may not clear. Again, they're personal checks. And so I would just instruct my client to destroy those post-dated checks. And I believe she hasn't cashed any of them yet, and she physically couldn't cash many of them. And so
all right, let me just make
I would
sure
suggest
we're
we
clear
just
on
destroy
that.
them.
Hold on. ask her to unmute.
I did cash a couple of those checks, and then I used that to pay child support.
Okay, so
what was the total amount?
Let's see. Philip, it was with the exception of the June, I do believe. I actually can let you know right now.
well, okay. Did you cash all of them but one? Is that what you're saying?
Yes, that's correct. So
Okay.
they were totaling $200 each.
So $800 is what you cash?
I believe so. Or
If he
yes,
gave you
8.
5,
What's that?
he gave you 5 checks and you've cashed 4,
Yes.
and each of them were for $200.
Yes.
Okay, so credit for $800 and destroy that other check. All right, we're adjourned. Thank you.
Your Honor, can I ask about the child support arrearages?
That is not before me today. All right, we're adjourned.
The court ultimately found contempt, ordered repayment within 30 days, granted credit for verified payments, and warned additional penalties could follow.